This is part two of the discussion segment. We left off with respect to the developing laws regarding sexual orientation and transsexuals. I want to call your attention to executive orders. That subject, as you are well aware, has been covered in the news recently. Executive orders are also sources for employment law. Executive orders originate by the executive of the United States, who is the president, or the executive of a state, that being the governor. With respect to Executive Order 13087, signed by President Clinton in 1998, a policy for the federal government was made to prohibit discrimination based on sexual orientation in federal government matters. The order did not create, however, any enforceable rights, such as seeking relief before the EEOC or through the courts. The executive order was a policy statement prohibiting discrimination on the basis of sexual orientation. That occurred back in 1988 with the issuance of such order by then President Clinton. In 2014, under Executive Order 13672, President Obama signed into effect the prohibition against such discrimination in federal contracting. So Executive Order 13672 in effect prohibits discrimination based on sexual orientation or gender identity with respect to federal contracting. Again, this information is covered in your supplemental materials. Within those materials, I wanted to bring your attention to some proposed legislation. One such proposed legislative act, entitled the Employment Non-Discrimination Act, ENDA, has been before Congress every term since 1994. It's never passed. That act, if it were enacted, would prohibit discrimination in hiring and employment on the basis of sexual orientation and gender identity by employers with at least 15 employees. There's also the Equality Act, which was a House bill that sought to amend Title VII to include protections that ban discrimination on the basis of sexual orientation, gender identity, and sex in the areas of employment, housing, public accommodation, and organizations which receive public funding. The term gender identity would include sex stereotypes, sexual orientation, and gender identity. Sexual orientation, according to the proposed legislation, would include homosexuality, heterosexuality, and bisexuality. That act has not been passed. However, the provisions mirror very closely the protected classification under Illinois law that relates to same. The EEOC position, which is also covered in your handout material, is interesting. I've included a number of items that have been proposed by the EEOC, lawsuits that have been forwarded by the EEOC or advanced in courts by the EEOC, raising LGBT discrimination and related matters. That's reading for you, which again will give you an overall perspective of how this fits under the sex prohibition category of Title VII. Turning to significant Supreme Court cases, I want to bring your attention to the 1989 case of Price Waterhouse versus Hopkins. That case also addressed sex stereotyping. The Supreme Court expanded the definition of sex in Price Waterhouse to include this notion of sex stereotyping. Hopkins was a senior manager in an accounting firm who was denied partnership allegedly because she exhibited perceived masculine traits. The firm advised that she could improve her chances for partnership if she attended a charm school and exhibited more feminine traits, including her appearance. The Supreme Court held that the firm discriminated against Hopkins because of sex. Note the Title VII application on the theory of sex stereotyping. After the Supreme Court case involving Price Waterhouse, many courts have recognized Title VII applications to gender stereotyping. We should also talk about the case of Oncali versus Sundowner Offshore Services. It's a 1998 Supreme Court case wherein same sexual harassment was recognized. We'll talk about that later in just a short while under the sexual harassment category. But Justice Scalia, who wrote the opinion, Justice Scalia is the justice who recently died, and his seat is now open and has recently received the appointment of a candidate to fill it, which will be the subject of upcoming Senate confirmation hearings. Scalia wrote that the critical issue in the Title VII text is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not likewise exposed. There's a number of other cases from the Supreme Court that fit within this overall context. The case involving United States versus Windsor, that's the Defense of Marriage Act case, and also the recent Supreme Court decision involving the Hodges case decided back in June of 2015 relating to same-sex right to marry in the context of benefits. And there's just a brief reference to that case in the material as well. The Illinois Human Rights Act, as I mentioned earlier, is very expansive in terms of recognizing rights involving sexual orientation, transsexual coverage issues, and that's certainly the law in our jurisdiction. Let's talk about the Audra Summers, also known as Timothy Cornish case. That's found in your textbook. The case is a district court decision that was decided in 1982. Well, many years later, this case is still reported in this national textbook, and it's highly relevant in terms of recent discussions about this very topic. I hope you read that case in detail. It's a very short read. Summers claims to be a female with the anatomical body of a male. She refers to herself in the female gender. She was fired 2 days after she was hired because she misrepresented herself as an anatomical female when she applied for the job. Summers' employer contended that her misrepresentation caused a disruption within the company's workforce, in that a number of female employees said they would quit if Summers was permitted to use the restroom facilities assigned to female personnel. Obviously, this topic is very newsworthy at even this current time with respect to a number of other applications. But Summers filed charges of discrimination with the EEOC and ultimately pursued her rights to court, alleging that she was discriminatorily discharged on the basis of sex in violation of Title VII. The court determined that Congress did not protect transsexuals from discrimination. Such discrimination, using the plain language of the text, according to this district court, was not within the ambit of the Act. Interesting case for our discussion and our application with respect to this area of law and its expansion that has been advanced by state legislatures such as in Illinois as well as the EEOC. Let's talk now about sexual harassment. And within the context of sexual harassment, we have to make a distinction between employer liability for supervisory harassment versus employer liability for non-supervisory harassment. In other words, harassment that originates from a coworker to another coworker. We must make that distinction so as to determine employer obligations and liability. Let's first discuss this concept called vicarious liability. Now, as we have read in our materials, in some of the supplemental materials introducing the course, we learned that a source of employment law is agency law. Other sources would be tort law, contract law, but agency law. The principal is the employer in an employment context. The agent is the employee. A legal fiction occurs with respect to actions carried out on behalf of the principal by the agent. The agent is actually within a legal fiction stepping into the so-called shoes, if you will, of the principal, therein representing the principal in place of that principal. So the actions which are carried out by the employee as agent, especially where there is a supervisory or management capacity, may bind the employer principal to liability. That's the concept of vicarious liability. We'll talk about vicarious liability and how it is more narrowed in the employment context later in the course when we discuss a theory and term called respondeat superior. And we'll define that term as it arises later on. Federal law prohibits workplace discrimination based on identified protected classifications. We know that. These laws are passed by Congress and signed by the President. I want to focus our attention now to these different enactments, regulations, and guidelines in terms of how they fit within the employment context. Regulations implement federal workplace discrimination laws. They are voted on by the EEOC after the public has a formal opportunity to provide comments to the EEOC. The statutory enactments originate from Congress and are signed by the President. Regulations are not statutory enactments. Regulations are matters which better define and apply those enactments. In your handout materials, again, for this section, you'll read that last year the EEOC produced for the public's comment information regarding its implementation for regulations involving retaliation. You may want to access that for your reference. EEOC sub-regulatory guidance or guidelines express the EEOC agency policy and explains how the laws and regulations apply to specific workplace situations. The guidelines are not administrative regulations, and courts are not bound by the EEOC guidelines. However, you may have already noted in your readings the case of Griggs versus Duke Power Company. In that case, the United States Supreme Court declared that EEOC guidelines should be shown great deference by the courts. The courts then, and not the EEOC, have the final determination in establishing law involving sexual harassment, race harassment, and other protected classifications identified for the workplace. If you have not already done so or discovered this website, please access www.eeoc.gov. That is the EEOC's website, and you will find, once you get into that website, EEOC guidelines. And you'll see when you examine those guidelines described cases and applications for conduct that relate to the rights of employees and the obligations of employers. I strongly recommend that if you haven't already done so, that you look at the EEOC website just for your reference and for your further understanding about this area of law. Let's examine harassment from the state and federal basis. Under federal law, it shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's sex. We know that. That's Title VII. The regulations define unwelcome sexual advances. You'll note in the federal statutory coverage, harassment is not used. It's further defined, however, within the regulations promulgated by the EEOC. And again, this is in your course materials. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when 1. Submission of such conduct is made either explicitly or implicitly a term or condition of an individual's employment. 2. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Or 3. Such conduct has the purpose or effect of unreasonably interfering with an individual's work performance, or, not and, but or, creating an intimidating, hostile, or offensive work environment. Please compare that statutory basis to the Illinois Human Rights Act. The Illinois Human Rights Act has a different level of statutory coverage. Under federal law, an employer is not liable unless the supervisor who commits sexual harassment is the victim's immediate or successively higher supervisor and has the power to directly affect the terms and conditions of the victim's employment. The federal prohibition against sexual harassment in employment is the result of a uniform holding of federal courts that sexual harassment is an aspect of Title VII's prohibition against sexual harassment because of sex. As noted earlier, Title VII does not include any direct text prohibiting sexual harassment. The Illinois Human Rights Act, however, prohibits discrimination on the basis of gender, but also includes a direct statutory prohibition against sexual harassment. Under federal law, there are affirmative defenses that can defeat an employee's claims of hostile work environment and sexual harassment. Under Title VII, which employers are held accountable, they may not necessarily be liable for sexual harassment because of the affirmative defenses. The Illinois Human Rights Act, however, imposes strict liability of the employer regardless of whether the employee knew of whether the employer knew of the offending conduct. Please note that distinction between state and federal harassment laws. There are two historical applications of sexual harassment theories. First, there is the quid pro quo tangible employment action that should be examined. That's again in your textbook and in your course materials, where a plaintiff proves that a tangible employment action resulted from a refusal to submit to a sexual demand. The supervisor is presumed to be acting within the authority of the company to cause the economic injury to the employee. Now, please note this. When a tangible employment action is involved, and when there is a quid pro quo relationship, quid pro quo is this for that. It's the most egregious form of sexual harassment. Employers are strictly liable for any harassment by a supervisory employee that leads to a tangible job detriment, such as a discharge, demotion, or even an undesirable reassignment. So think of a tangible action as being very similar to an adverse action, something bad that's happened. In effect, with agency law principles, the supervisor has been empowered by the employer as an agent of the employer to make decisions which affect employees under his or her supervisory control. The employer can raise no affirmative defense based on the application of the employer's anti-harassment policies when there has been a quid pro quo employment action. In other words, the liability, even under federal law, when there is a quid pro quo action, is strict. No defenses will defeat that strict liability. When we examine hostile work environment claims, we should also keep in mind this negligence standard, which is a tort standard involving reasonable care. There's information in your handout materials that define reasonable care and also discuss applicable standards for the sufficiency of harassment. I want to just comment on commonly considered examples of hostile work environment claims. I've broken them down into 4 categories. Categories involving verbal, nonverbal, physical, and visual context. And again, this is covered in your handout materials. Those examples I've not made up. The sources are from EEOC guidelines, court decisions, and other material. Please examine those categories carefully and the examples used within them. They'll give you an idea of hostile work environment situations which can bind liability to the employer for its actions and its inactions. I want you to turn to the Oncali case. That's in your textbook. And this case recognized same-sex sexual harassment as a violation of Title VII. This is a decision that was authored by Justice Scalia. Please examine this case in detail because it's very revealing. Obviously, it's still part of our common law heritage now, but it's good law in that it gives direction and understanding to the courts, attorneys, and human resource professionals. Justice Scalia notes that Title VII does not prohibit all verbal or physical harassment in the workplace. it is directed only at discrimination because of sex. He emphasizes that there is an objective severity of harassment that should be judged from the perspective of a reasonable person in the plaintiff's position, considering all the circumstances. And he relates this to a context. In same-sex, and Justice Scalia notes, in all harassment cases, the inquiry requires careful consideration of the social context in which a particular behavior occurs and is experienced by its target. A professional football player's working environment is not severely or pervasively abusive, for example, if the coach smacks him on the buttocks as he heads onto the field, even if the same behavior would reasonably be experienced as abusive by the coach's secretary, male or female, back at the office. The real social impact of workplace behavior often depends on a constellation of surrounding circumstances, expectations, and relationships which are not fully captured by a single or a simple recitation of words used or the physical acts performed. Here's what Justice Scalia says next. Common sense and an appropriate sensitivity to social context will enable courts and juries to distinguish between simple teasing or roughhousing among members of the same sex and conduct which a reasonable person in the plaintiff's position would find severely hostile or abusive. Those are the standards that remain in effect even today when examining this area of law. In your materials, there are other considerations that you should be aware of. For example, employer principles I've labeled as management of complaints, appropriate action, some suggested employer implementation, employee obligations, the recommendation for the development and utilization of sexual harassment policies with effective complaint reporting mechanisms. Again, all that is covered both within your text and in the handout materials. When we talk about hostile work environment issues, although this focus of the segment today is on sexual harassment, the same principles apply across the board to other protected classifications. So we may be talking about a hostile environment based on race or color or religion. We should use these same principles in recognizing what employer obligations and individual rights are. Lastly, I want to bring your attention to the adequacy of the employer's response to complaints of sexual harassment. There's always the concern that if the response is inadequate or improper, the response may cause more problems. And there's some information that's within your text and the course materials that highlight that, particularly with respect to retaliation. Harassment investigations must include practical considerations. These are recommendations. They're not absolute, but it's something to consider. The harassee and the harasser alleged should be interviewed. Credibility determinations are often made, and the EEOC has guidelines on how to address these issues. In fact, the EEOC has information that relates to reasonable harassment investigations that you might want to examine. Well, that concludes this segment of our discussion involving the assigned materials. We covered a lot of information very quickly. There's a lot of detail. Please continue to look at the text carefully and the course materials, which are supplied to give you further information and often more detail and practical implementation of some of these principles. Thank you.